evening friends. And there couldn't be a better way to start the online legal understanding of the aspects, especially when we celebrate 75 years of Constitution of India, by none other than Justice Indira Banerjee, a former judge from Supreme Court of India. And as we always say that when we can call for the speakers, they do not as such require any introduction because they have already created a mark and niche within the society. And once we embark on this thought process which we have started, and when we shared the idea with Justice Banerjee, as usual, her passion for sharing knowledge has been so forthcoming. And in this process, we also requested Justice Roshan Dalvi that once we have Justice Indira Banerjee, why don't you give some introduction about her and about the theme of these sessions which we will take. Justice Roshan Dalvi will also be part of this celebrations of 75 years of the Preamble of the Constitution of India. Over to you, Justice Dalvi, and we are so glad that both of you have accepted our invites. Over to you, Justice Roshan Dalvi.
Good evening, Vikas, and good evening, friends, and good evening, Justice Banerjee. More than anything, I was so happy to note, first, that Vikas has this idea of 75 sessions for 75 years of our Constitution. And I was even more intrigued and happy that Justice Banerjee is going to start and flag off this kind of series. It is a challenge for Vikas, and it is also a challenge for each one of us to choose a small topic from our Constitution so that we don't repeat what others have said. And I have given Vikas some 3-4 topics that if at all I have to, I would love to consider. The first and foremost is the preamble, and very well chosen by Justice Banerjee. A very renowned, a very erudite, learned, knowledgeable, and quiet judge. I have known her in an academic field. I have known her when I appeared before her in the Supreme Court. I have spoken with her, and at each time she came out larger than life. The topic that she has chosen, the preamble, is the first thing to begin with, and that gives the vision of our Constitution. And in these troubled days, we must see that we do not erode that vision which our Constitution framers have given us. In the quest for mission and passion, the vision should not be forgotten. And that is what Justice Banerjee would do. Thank you, Justice Banerjee, for being with us.
Thank you, ma'am, for giving us the kickstart. Yeah. We have already shared the flyer in this, of this journey of today's is really constitutional vision of justice, preamble of the Constitution of India. Over to you, Justice Banerjee, and thank you once again on behalf of the team of Beyond Law CLC for accepting our invite. And thank you, Justice Roshan Dalvi, to set the ball in the right motion. Over to you, ma'am.
A very good evening to you all, and I congratulate all of you, every one of us, the citizens of India, that our Constitution has completed 75 years of its glorious existence. And in another few days, it will be 75 years when all the provisions of the Constitution came into force. It was on 26 November 1949 when the people of India, acting through their representatives in the Constituent Assembly, adopted, enacted, and gave to themselves the lengthiest constitution in the world, consisting of 395 articles and 8 schedules. Today, of course, we have 10 schedules. The 9th schedule was introduced by the First Amendment Act as early as 1951, and the 10th schedule came later. The Constitution of India, like the constitutions of other countries which are written, lays down the basic framework of the system under which the people are to be governed. The Indian Constitution establishes the three main organs of the state: the legislature, the executive, and the judiciary. India is a federal state. Article 1 of the Constitution of India says that India, that is Bharat, shall be a union of states. In the special reference of 1956, the Supreme Court of India opined that the Indian Constitution is a federal one, even though some writers have called it a quasi-federal constitution. Explaining the use of the words Union of States, Dr. B.R. Ambedkar, chairperson of the drafting committee of the Constitution, said, "Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole, its people a single people, living under a single imperium derived from a single source." The federal framework under the Indian Constitution, however, has a centralized character. It is certainly not unitary because we have separation of powers between the union legislature, state legislatures. But at the same time, it is not strictly federal because residual powers lie with the states. In India, we have a people-centric constitution. The opening words of the Constitution, as enacted, read, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic." Of course, when the Constitution was enacted, initially, the words socialist and secular were not there. It was a sovereign democratic republic. However, with the 42nd Amendment, which came into force on 3rd January 1977, the words socialist and secular were incorporated in the preamble. The people of India, having constituted India into a sovereign, socialist, secular, democratic republic, promises to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote amongst all equality, fraternity, to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Of course, when the Constitution initially came into force, the words and integrity was not there. That was incorporated again by the 42nd Amendment Act, to which I referred a little while ago. In India, we have an idealistic constitution. It's a constitution with a vision. The basic scheme and the ideals and objects of the Constitution are summarized in its preamble. The preamble embodies the fundamental values and the philosophy on which the Constitution is based. The resolve was to constitute India into a sovereign democratic republic, securing justice, liberty, and equality to all its citizens. The ultimate aim is to ensure the dignity of the individual and the unity and integrity of the nation. Justice is further described as social, economic, and political justice. Justice covers everything. For the sake of emphasis, social, economic, and political have been mentioned. Liberty includes liberty of thought, expression, belief, faith, and worship. We have the freedom to think. The Constitution guarantees the freedom to think, the freedom to express, and that expression can be by words, it can be by a visual depiction, it can be in the form of art, so on and so forth. We have the liberty of belief, belief in a religion, belief in a system, belief in a philosophy, so on and so forth. We have liberty of faith and we have liberty of worship. At a session in a university, I was once asked, if you have been given liberty of faith, why was it necessary to mention worship separately? You can have faith in a particular religion. You can have faith in a particular system. You can have faith in a particular person. So, religion specifies a belief which is connected with spiritualism, whereas belief could be faith could be in a person, faith could be in a system. It can be totally secular, nothing to do with religion at all. Justice, liberty, equality, and fraternity are essential characteristics of any democratic order and elucidate the concept of a democratic republic. The ultimate goal is to secure the dignity of every individual and the unity and integrity of the nation. The words used in our Constitution are undoubtedly some of the noblest. They embody the highest values that human ingenuity and experience have been able to develop. Professor Sir Ernest Barker, the political scientist of Oxford University, was so impressed by the preamble that he used the words of the preamble in the preface to his treatise. In the Berubari case, the Supreme Court declared that the preamble was the key to the mind of the framers of the Constitution. where the words were found to be vague or their meaning was unclear, help of the preamble could be taken to understand the intention of the framers and to find out whether a particular word used in the Constitution was used in a wide or narrow context. However, in the Berubari case, Justice Gajendra Gadkar said the preamble was not part of the Constitution. It did not confer any substantial powers upon the legislatures or other organs of the state. These must have their source in express or implied grant by the provisions of the Constitution. Therefore, there are provisions, enforceable provisions in the Constitution, which support the values, the vision, the ideals embodied in the preamble to the Constitution of India. In Sajjan Singh versus State of Rajasthan, Justice Madholkar said that the preamble had the stamp of deep deliberation, was marked by precision, and the framers of the Constitution attached special significance to it. The preamble was an epitome of the broad features of the Constitution, which were an amplification or concretization of the concepts set out in the preamble. The earlier Supreme Court opinion regarding the preamble not being a part of the Constitution was liable to be reviewed. This was the opinion. Justice Hidayatullah also invoked the preamble to the Constitution in aid of construction. In Golaknath versus the State of Punjab, Justice Hidayatullah observed that the preamble to the Constitution of India epitomized principles on which the government was to function. The preamble was the very soul of the Constitution, eternal and unalterable. He said, our preamble was the declaration of our faith and belief in certain fundamentals of national life, a standard from which we must not depart, and a resolve we must not shake. What strong words. In Bharti Bhavan Chandra versus State of Mysore, which was reported in All India Reporter 1970, Supreme Court 202, the Supreme Court held that the directive principles of state policy and the fundamental rights could better be understood in the light of the objectives enshrined in the preamble. In Keshavananda Bharati versus State of Kerala, a landmark decision, the majority of the judges referred to the constituent. The majority of the judges referred to the Constituent Assembly debates, the discussions, and found and held that the preamble was part of the Constitution. And observations to the contrary in the Berubari case were not correct. The preamble contained the basic structure of the Constitution. Justice Sikri said that the legislative history of the preamble to the Constitution justified its importance. The preamble was not only part of the Constitution, but was of extreme importance. To quote him, of extreme importance, and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. Any provision of the Constitution could be amended under Article 368, but only within the broad contours of the preamble and of the Constitution. Our Constitution framers realized that you cannot have a completely rigid, unchangeable Constitution. Situations may require amendments. With passage of time, there may be developments which may require amendment to the Constitution. But in the Keshavananda Bharati case, the Supreme Court said all provisions of the Constitution may be amendable, but you cannot make such amendments as will rob the Constitution of its basic elements. You can't remove the edifice of the Constitution. The basic features of the Constitution ought not to be altered. In fact, the inalienable basic elements of the Constitution were sought to be traced from the words of the preamble, and it was held that the provisions of the Constitution could not be amended so as to alter the basic elements. Although the basic elements were not precisely defined, those mentioned in the preamble were specifically included. In the words of the Supreme Court, the edifice of our Constitution is based upon the basic elements mentioned in the preamble. If any of those elements are removed, the structure will not survive, and it will not be the same Constitution, or it cannot maintain its identity. Even though the preamble is now taken to be an inviolable part of the Constitution, and it assumes special position as an aid to construction, as an aid to interpretation of the Constitution, it is a fact that it is not in itself enforceable. To quote Justice Matthew in Indira Nehru, Gandhi versus Rajnaran, it was neither a source of any power nor a limitation thereof. Now, with the 42nd Amendment Act, the words socialist and secular were incorporated in the Constitution. Why were these words incorporated? The question is often asked. These amendments were considered clarificatory in nature. These were implicitly there in the preamble and in the rest of the Constitution. Our Constitution was always a secular Constitution. It was always a socialist Constitution, and this is apparent from the various other provisions which are there in the Constitution itself. let us say, freedom of faith, freedom of worship. These were there from the very inception, long before the word secular was even incorporated in the preamble. Similarly, socialist. The Constitution spoke of social justice. The Constitution contained various provisions of the directive principles of state policy, which point towards a socialistic order. Similarly, unity and integrity. Now, there is a slight difference between unity and integrity. Unity is to be united, and integrity is to be one. And emphasis was given on the nation being one, though states might be different. In Bommai versus Union of India, Justice Raman, I think it was 1994 Supreme Court, missed out the page reference. Justice Ramaswamy said, the preamble of the Constitution is an integral part of the Constitution. Democratic form of government, federal structure, unity and integrity of the nation, secularism, and social justice and judicial review are basic features of the Constitution. So these features cannot be amended. From the preamble as it stands today, it may be said that the fundamental Constitution values which the founding fathers of the Constitution wanted to foster were sovereignty, socialism, secularism, democracy, a republican form of government, republic, where, unlike a monarchical hereditary form of government, where you have a republic, where you have an elected head of the state, our founding fathers wanted to secure justice, liberty, equality, fraternity, dignity of the individual, unity and integrity of the nation. And all these features constitute basic elements of the Constitution of India. Now, what exactly do we mean by sovereignty? A sovereign state connotes state with power which is not subject to any external or even internal authority. The sovereign state does not acknowledge any superior. In Kesavananda Bharati, Justice Matthew said that the Republic of India was sovereign because it could make or unmake any decision with respect to itself without any interference from outside. The word sovereignty has not been defined anywhere, but we find the use of the word in Article 19. Article 19, subarticle 2 says nothing in subclause A of clause 1 that is freedom of speech and expression, shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of the sovereignty and integrity of India. We also find the use of the expression sovereignty in the oath of office, which we all judges take under the third schedule to the Constitution of India. The oath reads, I will bear true faith and allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, that I will duly and faithfully and to the best of my knowledge and judgment perform the duties of my office without fear or favor, affection or ill will, and that I will uphold the Constitution and the laws. Of course, to give effect to the noble ideals embodied in the preamble, you need a strong, independent judiciary, because the judiciary is considered the guardian of the Constitution. It is the judiciary which interprets the Constitution, and the manner in which the Constitution is interpreted by the judiciary is the last word on its interpretation. As you know, there are criticisms about development of the basic feature theory, the finding of the Supreme Court that certain provisions of the Constitution are unaltered. But the fact remains that this is a judicial pronouncement. It is binding on all. So no matter what people have to say, it is the law that certain provisions of the Constitution, which go to the root of the Constitution, which hit at the basic features, cannot be altered, they cannot be amended. Now, coming to socialism. Why was socialism not incorporated initially? Why was it incorporated later? Possibly because the founding fathers did not want to adopt any particular ideology or to be limited by any doctrine. But as I already mentioned, the basic tenets of a socialist order were there within the Constitution. The preamble did mention the resolve to secure to all its citizens justice, social, economic, and political. So, economic justice. Socialism, a socialistic order ensures economic justice for all. there was an attempt to bring in an amendment in the Constitution defining what exactly socialism was. And that was the 45th Amendment Bill. But ultimately, it was enacted as the 44th Amendment Act, but it did not define socialism, and nor did it identify the basic features of the Constitution, which was thought to be done by introduction of the 45th Amendment Bill. In India, the Constitution is people-centric, as I've told you. Now, to secular. The other amendment was introduction of the word secular. Now, what exactly do we mean by secular? The ordinary dictionary meaning of secular would be something which is unconnected with religion, which has nothing to do with religion. But then, there are various concepts of secularism. Now, let us say the Constitution of Bangladesh. It is an Islamic state. The Constitution proclaims Bangladesh to be an Islamic state. Yet, the Constitution says that it is secular, because secular is understood to mean that there would be no discrimination on the ground of religious belief, nor any favoritism on the ground of religious belief. Whether that happens everywhere or not, that is a different issue altogether. If that is not happening, it's in contravention of their constitution. An academic definition of the concept of secularism was attempted in the following words: the secular state is a state which gives individual and corporate freedom of religion, is not constitutionally connected to a particular religion, nor does it seek either to promote or to interfere with religion. I think one could usefully refer to the judgment of Justice Beg in Ziauddin Barhumuddin Bukhari versus Brijmohan Ramdas, Mehra and Brothers. Justice Beg said, the secular state, rising above all differences of religion, attempts to secure the good of all its citizens, irrespective of their religious beliefs and practices. It is neutral or impartial in extending its benefits to citizens of all castes and creeds. Maitland has pointed out that a state has to ensure through its laws that the existence or exercise of political or civil right, or the right or capacity to occupy any office or position under it, or to perform any public duty connected with it, does not depend upon the profession or practice of any particular religion. Our Constitution and the laws framed thereunder leave citizens free to work out happy and harmonious relationships between their religious and quite separable secular fields. Secular fields of law and politics. But they do not permit unjustifiable invasion of what belongs to one sphere by what appertains really to another. It is for courts to determine in a case of dispute whether any sphere was or was not properly interfered with in accordance with the Constitution. Anything that is pernicious and exploitative cannot be allowed to remain outside the control of law, simply because it is paraded under the garb of religion. Justices Gajendra Gatkar, Dhawan and Beg found secularism practiced by ancient Hindu society and equally traceable to Islamic jurisprudence. Justice Beg suggested that a happy harmony and synthesis of the best in secularism and religion was possible. A theory of secularism could be built on ancient jurisprudence. In S.R. Bommai versus Union of India, the Supreme Court dwelt at length on the basic feature of secularism in the Constitution and justified the proclamations under Article 356, imposing precedence rule in the BJP-ruled states in the aftermath of the Babri Masjid demolition, on the ground of threat to secularism, which it held to be a basic feature of the Constitution, and one that was there even before the word secular was inserted in the Constitution. Unfortunately, freedom of religion and certain religious beliefs and practices hit at the root of Article 14. And it becomes problematic for courts, not only in India, but elsewhere, to secure true gender justice by reason of prevalent religious practices. But then, of course, what is protected under the right to religion is essential religious practices and not practices in the name of religion which are not part of essential religious practices. Democratic and republic, which I have already referred to, hardly need any explanation. We have universal suffrage. Every person has a right to vote. Every person has a right to contest elections subject to the basic eligibility criteria. Now, coming to justice. What exactly is justice? That which is securing to a person that which is rightfully due to a person. It is important to remember who is responsible for delivery of justice. Not the judiciary alone. Many people associate justice or justice delivery with the judiciary. Justice is delivered by the legislature which enacts the law, by the executive which implements the law, of course by the judiciary which interprets the law, by the society at large. When a girl child and a boy child are discriminated within the family, it's the family which is doing injustice. Similarly, the members of the family can also secure justice for us. As I've always said, to be sensitized and to be good citizens is as important as having laws and provisions to secure complete justice. Now, the courts as the interpreter of the Constitution have been called upon to decide cases. Now, when it came to liberty, the earlier view taken by the courts used to be that it was a protection against arbitrariness in executive action. If there was a law, then deprivation of liberty was permissible. That was the view which had been taken in the Gopalan case. But over the years, Supreme Court Supreme Court took a different view in the Maneka Gandhi case, where it says that not only the executive action, but even the procedure followed, the law, that could also be scrutinized by the courts. Now, before we conclude, just a few comments on the Constitution. Dr. Ambedkar had remarked, the Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit, always the spirit of the age. The preamble of the Constitution is the soul of the Constitution. It is an expression of the dreams and aspirations of the people of India. Jawaharlal Nehru, the first Prime Minister of India, said, "Preamble is a way of declaring to the world the fundamental ideals that inspire the Constitution. It tells us what we stand for, what we want to achieve, and what kind of society we wish to build." Justice Vallabhbhai Patel said, the Constitution of India, and particularly its preamble, reflects the aspirations, values, and our resolve to build a just and equitable society based on the rule of law. And our first President of India, Dr. Rajendra Prasad, said, the preamble is not a mere introduction to the Constitution, but it contains the essence of the Constitution, its ideals and its values. It reflects the collective will of the people of India. Sarvapalli Radhakrishnan, the second President of India, said, the Constitution of India is a symbol of our struggle for freedom. The preamble of the Constitution is a pledge to establish a society based on justice, equality, and freedom. Questions often rise as to how far have we been able to live up to that pledge. Dr. Ambedkar had sounded a caution, saying, I feel a good constitution may be, it is sure to turn out bad. I feel however good a constitution may be, it is sure to turn out bad, because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The working of a constitution does not depend wholly upon the nature of the constitution. The constitution can provide only the organs of state, such as the legislature, the executive, and judiciary. The factors on which the working of those organs of the state depends are the people and the political parties they will set up as their instruments to carry out their wishes and their politics. Who can say how the people of India and their parties will behave? In addition to our old enemies in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will Indians place the country above their creed, or will they place creed above the country? A very poignant question. He says, I do not know. But this much is certain, that if the parties place creed above country, our independence will be put in jeopardy a second time and probably be lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. Dr. Rajendra Prasad, in his concluding speech, observed that they had been able, on the whole, to draft a good constitution, which he trusted would serve the country well. But he also added, if the people who are elected are capable and men of character and integrity, they would be able to make the best, even of a defective constitution. But if they are lacking in these, the constitution cannot help the country. After all, a constitution, like a machine, is a lifeless thing. It acquires life because of men who control it and operate it. And India needs today nothing more than a set of honest men who will have the interest of the country before them. There is a vociferous tendency arising out of various elements in our life. We have communal differences, caste differences, language differences, provincial differences, and so forth. It requires men of strong character, men of vision, men who will not sacrifice the interests of the country at large for the sake of smaller groups and areas, and who will rise over the prejudices which are born of these differences. We can only hope that the country will throw up such men in abundance. I think we all have a duty to give effect to the Constitution, whatever be the field. The members of the legislature, who are the representatives of the people, the bureaucracy, the judiciary, and the lawyers have a very important role to play. I, as a judge, can confess that the best judgments came when the arguments were good, when the lawyers were well prepared. The academicians assist in the development of the law. So I do hope that our Constitution will go on. It will fulfill the aspirations of the people, and we will have a healthy, egalitarian society, a healthy democracy. Thank you very much.
Thank you, ma'am. I think you have set the tone in the right manner. And we are also thankful to NIMS University in Chandigarh, who has been our knowledge partner in these sessions. And tomorrow, part 2 would be Fundamental Duties, the Value-Based Education, that is by Justice Paramjit Singh Dhaliwal, a former judge from Punjab and Haryana High Court, and now he's a senior advocate. So do stay connected at tomorrow at 6 p.m. And ma'am, the way you have taken us through the entire journey, coupled with the legal aspects, I'm quite sure that a lot of legal minds would be ignited, and they will also imbibe the values which the Constitution has done. And we have seen that the government of the today is also working upon it. And thank you, ma'am, once again for, I know that we caught you at a late time, but still you accepted our invite. We are always grateful to you. And thank you, ma'am.
Thank you. Thank you. It's always a pleasure.
Yes, that's what Rashmi Khurana from NIMS told, that you always had a passion for teaching, and that's what make us people like us.
I would have been happy if I could prepare myself a little more.
Once it is without preparation, such a good manner, that once if it is prepared, I do not know where we will reach. Thank you, ma'am. Namaskar.
Thank you. Thank you.